Hello and welcome back to our series on intellectual property and its role in legal English. So far, we've talked about patents and trademarks, and we're starting our discussion now on copyright. Copyrights are a fantastic subject that I love talking about, and my only fear now is that we're going to make one video that is far too long. Before we get into the content, my name is Jeff Keiser. I'm a lawyer. I'm a legal English teacher. I'm a traveler. I've taught people around the world, and my goal is to help spread good legal English to lawyers and law firms all over the planet. I'm happy to be here with you today, and I hope you're happy to hear me. So copyright, what is it? Put simply, it's the legal right of the owner of intellectual property. And the word itself gives away a little bit of what it is. It's the right to copy your work. This means that the original creators of products or works of art and anyone that they authorize are the only ones with the right to reproduce that work. There are other rights associated with copyright. Don't worry, it's more than just the right to copy. But copyright law gives the creators of original material, that exclusive right to use and duplicate that material for an amount of time. After that time runs out, copyright goes away, and that information enters the public domain. We'll talk about the public domain a little bit later. Anytime someone creates a product or a writing or a movie or a musical work that is original, that requires mental activity to create, it becomes intellectual property that must be protected from unauthorized duplication. One safeguard that we can use is a copyright. Copyright is a form of legal protection granted to authors of original works of authorship, including literary, artistic, musical, and other intellectual creations. One of the requirements of any copyright is that it must be reduced to a tangible medium. This is a physical form that the authorship can be expressed in. It's the book, the painting, even a digital file. It's not listening to the music. It's the composition of the music in a written form. So, things that are copywritten generally are computer software, art, poetry, graphic design, musical lyrics and compositions, even though they might need an independent copyright. Novels, films, architectural designs, website content can and should be copywritten. And in the United States, copyright comes from the U.S. Constitution. This means that, and when something comes from the Constitution, it's the ultimate law of the land. And in Article 1, Section 8, Clause 8, it states that the Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Obviously, that also applies to patents, but the constitutional basis is an important starting point for our analysis of intellectual property. "200 years later, that purpose has not really changed. The Supreme Court put this really, really well. The immediate effect of our copyright law is to secure a fair return for an author's creative labor. But the ultimate aim is, by this incentive, to stimulate artistic creativity for the general public good. In other words, if we wrote a book or made a movie or wrote a song and we never got paid for it, what's the point? I don't want to say that it's all about the money, because being a creative artist is also very important. But we need to incentivize people to be creative. It's a beautiful thing, and it's one of the great things about our society, and most societies that protect copyright. So there are a number of elements of copyright that we have to prove to get one. The first one is originality. It needs to be an original work of the author. This is different than a novel, the novelty aspect of a patent. But it really just means that the work can't just be a copy of something else. It's an original work. It has to be creative. It has to show creativity. The U.S. Supreme Court has said that works only need to have a modicum of creativity to be creative enough for copyright. A modicum, I don't know the official definition right off the top of my head, but it's a very low bar to meet. It's very easy to have a modicum of anything. It has to be fixed. It has to be on a tangible medium, like we said earlier. You can't copyright a speech by just speaking it out loud. But if you record that speech, then it's fixed in a tangible medium, and you can have a copyright over it. For example, this presentation right now is being fixed in a digital medium, which is still tangible and could be copyrighted if we choose to. Even if it's copied into the RAM memory of a computer, that is enough to be fixed. So, it's original if it's created from independent thinking, void of duplication. This is what makes it an original work of authorship. And anyone with an original work of authorship automatically has the copyright to that work. We don't need to register it. We should, but that's a different subject. We can register it voluntarily, but that's just for evidence in the event that there's a dispute in the future. This happens a lot in the film business, where even though somebody might write a screenplay that people love, they don't register it. Maybe the studio steals it, and that person has a hard time proving that they stole it. That's where registration helps. Copyright lasts, in the United States anyway, the entirety of the author's life plus 70 years. Okay? Now, if the author is a corporation, as under that work for hire doctrine we spoke about way back in one of the early videos, then the corporation holds the IP rights. They're not going to die like a person will. So the length of the term of copyright protection for them is 95 years from the date of publication, or 120 years, whichever happens first. Long after we're dead and gone anyway. It's different in each country. Sometimes it's 50 years, sometimes it's 100 years. So look into your own jurisdiction a little bit to try to learn about how copyright works, how long one lasts. What happens after that time runs out, after 70 years past the author's death? Well, a work can enter the public domain. And this is more or less the Wild West of intellectual property. There are no rules. Once something is in the public domain, you can copy it, you can sell it, you can distribute it, You can alter it. You can do whatever you want with it. Anyone can use it any way they want. Now, this is where it gets a little tricky. If you were to take a work in the public domain and change it, let's say you make let's see here, a horror film version of the Pinocchio story. Well, your work is a derivative work and is entitled to copyright protection again. This is very complicated stuff here, and it's really interesting. You can look at Disney films from the last 10 years or so and see how they've modified works. The movie Frozen comes from a Norse story, children's story, that went into the public domain. Now, Disney wanted to make their own copywritten material, so they changed the name, they changed some of the characters, they added things to it, and it is a derivative work that is very copyrighted by Disney. Now, unlike patents, which do not have international strength, copyright does. And this is done through a number of treaties. Whether it's the World Intellectual Property Organization Copyright Treaty or others. This means that copyright in the United States will be protected in Asia or South America, and vice versa. Oftentimes, these protections are theoretical in nature, and it's not always easy to win based on treaties, but at least we know there is some kind of protection there, and that's good. All right, guys, that was a long video, but I hope it wasn't too painful. Next time, we're going to talk more about copyrights, what they are specifically, and what we can do to enforce them. Until then, have a fantastic day, and I will see you very soon.